Hello friends, this is the very first video of a series of videos that I'm going to do here. These videos will help you understand important principles and methods. So let's get started. Today I am approaching the basic structure doctrine. Now while discussing this topic, two very important articles are Article 13 and Article 368 of the Constitution. Now Article 13 serves as the protector of the fundamental rights, whereas Article 368 holds the power to amend the Constitution. Now when you clash Article 13 with Article 368, some very important questions come before us. Like, can the Constitution be amended by the Parliament? Can the preamble be amended? Can the fundamental rights be amended? And the most important of it all is the amending power of the Parliament exercised under 368 absolute? Are there any restrictions on it? But in the end, you will realize the whole discussion is a tussle for power. The question is, who's supreme? The Supreme Court or the Parliament? So we'll decide what the answer is in the series of events that I'm going to discuss now. Now the first case in this discussion is the Shankari Prasad versus Union of India. The first Constitutional Amendment Act was challenged in this case. Now the first Amendment Act, amongst other things, is widely known for the abolition of zamindari system. So what happened in this Amendment Act was, there were certain laws that were brought about which were curtailing the right to property. And in order to protect those laws, Article 31A and 31B were inserted in the Constitution. So people started looking at 31A and 31B as an attack on the right to property. So the question arose whether the right to property can be usurped, whether the parliamentarians amend the fundamental rights. The judgment followed that Article 13 Clause 2, which is a protector of the fundamental rights, the word law in it only means law in ordinary sense. That is, when law is made exercising the legislative power and not constituent authority. Therefore, Article 368 includes the power to amend the fundamental rights. Now the next case in this discussion is the Sajjan Singh versus State of Rajasthan. The 17th Amendment Act was challenged. Why? Because it was restricting the powers of the High Court. Now again the discussion started, what can be amended, what cannot be amended. So in this particular case, they took a view of the earlier case, that is the Shankari Prasad case, and said that the meaning of the words amendment of this constitution under Article 368 meant amendment of any part of the constitution, including fundamental rights. Justice Hidayatullah and Mudholkar had a little difficulty accepting the view that the fundamental rights are nothing fundamental to the constitution. Even they can be amended like other parts of the constitution. In this judgment, it was also said that even if Article 368 did not have the power to amend the fundamental right, the parliamentarians can at any point of time do a suitable amendment and include those powers. So finally, in Sajjan Singh versus State of Rajasthan, it was settled that yes, the whole of the constitution, including the fundamental rights, can be amended. The next case is of Golaknath versus State of Punjab. Again, the 17th Amendment Act was challenged. This time the question was whether the power to amend the fundamental right is unlimited or limited. Now this case is important because an 11-judge bench was constituted. Such a large bench was constituted for the first time. In this case, everything was reversed. The Supreme Court said that the power to amend the constitution, including the fundamental right, is not an unlimited power. It is subject to limitations of judicial review. So this case is important because until now we had a settled position that 368 had an unlimited power. That is, even 13 could not stop 368. But this case reversed the position and said what? No. 368 is subject to limitations of judicial review. The Supreme Court even went ahead and said that Parliament does not have any power to amend or abridge the fundamental right in the way of amendments. Further, the ambit of Article 13 Clause 2 was discussed. They said that the word law used under Article 13 Clause 2 includes amendment, and if any amendment violates fundamental right, it would be void. So you see, up till now there has been a tussle for power, for who's supreme, whether the judiciary is supreme or the parliament is supreme. In the Shankari Prasad case, it was settled that the parliament is supreme. In the Sajjan Singh case, Again, it was said that the parliament is supreme. But for the first time in the Golaknath versus State of Punjab case, it was said no. Article 368 is subject to limitations imposed under Article 13. So the judiciary is supreme. Now in a movie, if you have two heroes, the first hero comes up and says, I am supreme. We all know that in the next scene only, the second hero would come up, hit the first hero and say, but you were mistaken, I am supreme. Similar is what happened next. The parliamentarians could not digest what happened in the Golaknath case. So they came up with the 24th Amendment Act. They did the following changes in Article 13 and 368. First, in Article 13, they included 13 Clause 4, which said that nothing in Article 13 would apply to 368, which means that anything can be done under 368 and it would not attract the attention of judicial review under 13. Then, under Article 368, they changed their marginal heading. Previously, it was the procedure for amending the constitution. Now it reads, the power of the parliament to amend the constitution and the procedure thereof. Lastly, they added clause 3 to 368, which said, nothing in Article 13 shall apply to 368. So the crux of the 24th Amendment was to exclude the applicability of Article 13 onto Article 368. Therefore, everything that was held in the Golaknath case holds no value after the 24th Amendment Act. After the 24th Amendment Act, it was clear that the Parliament can dilute the Constitution, including the fundamental rights. Now, our next case needs no special mention. It's the Kesavananda Bharati case. Again, the 24th Amendment Act was challenged. The question arose that what is the scope of amendment that the Parliament reserves? Now, this time, the Supreme Court gave a very balanced judgment. They said that the power to amend the Constitution was already implicit in the Constitution. The 24th Amendment Act merely made it explicit or declaratory. However, they said that the basic features cannot be amended. So in simple words, the crux of Kesavananda Bharati case is that you can amend the entire Constitution to form a new Constitution. However, it should survive through its basic features, which means that there are certain implied restrictions for amending the Constitution and the basic features cannot be amended. Coming to the question of scope of amendment under Article 368, the Supreme Court said that it was not the intention of the constitutional makers to use the word in its widest sense. It was their intention and belief that fundamental rights along with fundamental features would always survive through in a welfare state. Now the question comes, how far can the provisions of Article 368 be amended? The Supreme Court said that an increase or decrease in the power of 368 should be such that it should not lead to total destruction of the powers, and a decrease should be such that it should not mean freeing from all restrictions. So what they mean was, any increase or decrease in the power of Article 368 should not authorize the legislature to destroy the basic features of the Constitution. That's it. Our next case is very important as it qualified certain features as basic features. Also, through this case, Clause 4 and Clause 5 were added to Article 368. Now, what was the importance of these two clauses? These clauses said that even if Part 3 of the Constitution was amended, it cannot be questioned in any court. They clearly said that there is no limitation on the power of the Parliament to amend the Constitution. Now this case put an end to the controversy of who's supreme, the Supreme Court or the Parliament. They said that the Parliament represents the will of the people, and if the people want to amend the Constitution, they can exercise their power through the Parliament. There should be no limitation on that. The Supreme Court in this case also said that the theory of basic structure is very ambiguous and vague, and addition of Clause 4 and Clause 5 in Article 368 rectifies the situation. Now this is the last case for our discussion. In this case, the validity of the 42nd Amendment Act as well as the two clauses that were inserted by the 42nd Amendment were challenged. The Supreme Court said that these two articles were attacking the basic features of the Constitution. Therefore, the Supreme Court held it unconstitutional. After this case, it was finally settled that the constitution is supreme and the parliament cannot exercise unlimited amending powers. And finally, it was said that the constitution is a precious heritage and therefore you cannot destroy its identity. Hi friends, I hope you are understanding what I am teaching here. Do comment below the topics in which you need help. That's it for today. Meet you in next class. Bye bye.